very grateful for this opportunity to share some thoughts with you. Very grateful to the interpreters, to Russian and Turkish, for their efforts. And so many thanks from the beginning to the organizers for having me here. I'm an expert in law and religion, a lawyer by training, used to look at religion in all its implications, but this is just to suggest this presentation will be very much influenced, of course, from the very specific perspective of a legal scholar. And the 3 points that I will briefly touch upon are, in fact, dependent from my very perspective as a scholar in law and religion. So one first extremely brief point will be about what does the legal perspective on tensions around the contribution of religion to employment mean in the perspective of the religious contribution to a decent, productive employment. And my analysis here will be limited to my continent, Europe. Then I will look at 4 categories of framework which are very fundamental for the kind of encounter between religion and employment that I will look at. And finally, third point, 8 decisive factors. Now, where does my presentation come from? A number of very relevant studies and researchers. And of course, I wish to mention once again the Religare project, which has been foundational for us scholars in law religion in Europe, but also the very, very important study from the UN Special Rapporteur that we had yesterday addressing us during the dinner, and that is also a very important document. Now, for the sake of this very specific presentation, I will mostly rely on the proceedings of a workshop which took place very, very recently, just last week, from Thursday to Saturday, near Madrid, at the University of Alcalá, and which gathered experts in law and religion around precisely this theme of religion in the workplace. So I'm very grateful to my colleagues in this consortium, and I'm very grateful, I will repeat my thanks, they are down at the bottom of the slide, to Mark Hill, a QC, who's here with us. Thank you, Mark. So many, many thanks, because especially the second point is literally drawn from his conclusions to this Alcalá meeting. Now, this is the very fundamental question when we look at the legal dimension of tensions arising from the encounter of religion and the employment. So as we look at these legal tensions, what are we saying in fact about the very topic of our session, which is the contribution of religion to productive, decent employment? Now, I will briefly sketch an answer using one document from a British independent body, ACAS, Advisory, Conciliation and Arbitration Service for employers and employees in Britain. This organization issued in 2005 guidelines for employers and employees for accommodation of religion or belief in the workplace. Let me quote a brief passage from the introduction to these guidelines. I quote, "Fairness at work and good job performance go hand in hand. Tackling discrimination helps to attract, motivate, and retain staff and enhances an organization's reputation as an employer." Now, this is just one possible explanation of the tie which exists between a sensible management of tensions arising from religion or belief in the workplace, pointing, as you can see, at, on the one hand, the quality of the job performance, and on the other, on attracting, motivating, retaining staff, and third, the reputation of the organization. I suppose that the list might be longer, but this is just an example of how looking at legal management and policies, private or public, in this area are in fact very relevant to a much wider topic, which is productive and decent employment and the role of religion in it. Now, what about these four categories of framework under which we have observed the encounter of religion and deployment taking place in Europe? Which are also the four fundamental categories under which we should try to understand issues and solution to issues. First category, a person of faith employed by a private company. So we're not here looking at the configuration of the private company. We're rather focusing on the fact that the person, the employee, might have a religious affiliation, might have a strong religious conviction, and of course he or she is not willing to leave this conviction at home when he or she goes to work. A second hypothesis or category is a person of faith employed by the state. Problems do not arise in the same way in the different countries in Europe. There are countries in Europe who are, for different reasons, more tolerant towards certain kinds of religious behaviors on the workplace. Others who have pretty high requirements which are resented as discriminatory very often by employers. So this is the second category. A third category is employment by an organization with a religious ethos. And fourth, ministers of religion who are in fact employed into the organization. So for each of the four categories are very relevant because they shape conflicts. And they shape, in fact, also responses to conflicts. Well, what is very important to understand is that each of the four is undergoing challenge and change. So what we mean by each of the four is under a lot of pressure for change. What we understand in Europe for a private company is changing. What we understand for the state requirements vis-à-vis religion is changing. The same applies to organizations with religious ethos. And the same also applies to ministers of religion. Just to think of the fact that this category has been, of course, shaped in the law in Europe based on Christian churches, and that the adaptation of these categories to religious traditions that understand in a completely different way their organizations and special positions within their organization is, of course, a challenge in society and in the law. And let me also stress that these four categories also interact with one another. Now, the final point in my presentation is pointing at 8 factors which are very important when we deal with conflicts that come out in those 4 categories. And in fact, this again is about, on the one hand, looking at how conflicts and tensions arise, so it's more a sort of observation on an objective level. But I would also like to underline that for academics, experts, and the civil society, religious organizations, I would argue that it is very important to pay increasing attention to how to handle each of these 8 factors. This is really, I believe, a part of the exercise which is required in view of the end that we set to ourselves, being careful and towards each of the 8, which I will very, very briefly mention now. Now, one point which I wish to underline when we look at crisis on the ground, tensions on the ground, and when we look at the case law, this is very apparent, is that we must care for circumstances and context. Our fact-finding at that level is often very poor, very inaccurate. Second element, how we draw the line between public and private. We mentioned before, the state as the employer, a private company as the employer. A lot is changing there, and drawing the limits and the consequences of the line that we draw is very influential and very difficult. The criteria of a duty of loyalty, and especially this expression that has been used by the European Court of Strasbourg, heightened duty of loyalty. This also deserves a lot of careful reflection. What does it mean that this duty of loyalty bounds in a special way an employee to an employer on both sides? A ministerial exemption as far as religious ministers are concerned. How do we frame, again, this exemption? To what extent? Towards which kind of employer? Contractual arrangements. How is it desirable that we invite and encourage private partners, especially in the private sector, to carefully draft and define their arrangements, and then again, to what extent those contractual arrangements should be binding, especially vis-à-vis conversions. We had a case in Germany where an employee who was accepted as a Catholic in a Protestant kindergarten was no longer accepted and dismissed because he had converted to another Christian church, for instance. Grounds for dismissal. What about the difference in particular, especially in organizations with a religious ethos or within churches, between grounds for dismissal that would depend on an objective behavior, concretely and objectively impinging upon the performance on the job on the one hand, and on the other hand, moral requirements, being pregnant, or divorce, or other elements of sexual orientation. And seventh factor, the position within the organization. We have an interesting string of cases before the European Court of Human Rights where the court has judged differently different cases based on the degree to which the person concerned was closer or farther to the core of the organization. So should we treat a gardener differently from a teacher, both employed by religious organizations because their proximity to the core religious message is different, or should we consider those positions in the same way? And lastly, due process. Can we require religious organizations or organizations with religious ethos to apply due process and fundamental criteria like the right to be heard as we require those in any kind of employment relation? Is that fair? Is that possible? Which are the consequences? So just 8 factors which seem to me as emerging as the challenge for all of us, as I mentioned, both from the point of view of the observation of how conflicts actually happen in society, but also as an invitation to shape our expertise and as an invitation to look from this perspective at the connection between a appropriate, sensitive, careful work on the phenomenology of conflict and the much bigger and broader question on how religion can contribute to productive, decent employment. Thank you very much.